Was it specifically, do you think, judging from the judgment, to do with negligence, or just they had never encountered this experience before and they didn't know what to do, or was there something more to it? Can you just outline specifically what was decided in this court case first?
So Siouxsie Wiles brought concerns to the University of Auckland around the harassment that she was experiencing during the COVID-19 pandemic. Ultimately, this decision decides, A, what the employer's obligations were to provide a safe workplace for her, and also specifically looks into the situation with Siouxsie and the relevant events surrounding what actually happened. Was her employment disadvantaged, and did the employer breach its various legal obligations?
And what did they find in terms of the employer breaching its obligations? What specifically did they find?
So they did find that the employer failed to provide a safe workplace for Siouxsie and essentially breached its health and safety obligations. So it found that while the university had good intentions and were making efforts to try and minimise harm that she was suffering, or minimise the harassment she was experiencing, ultimately the university didn't go far enough and didn't complete its legal obligations, including to act in good faith.
Was it specifically, do you think, judging from the judgment, to do with negligence, or just they had never encountered this experience before and they didn't know what to do, or was there something more to it?
I think it's a fine line. I think they knew, they had some expectation of what could come, and that was seen. The university already had a harassment sort of task force put together to assist staff in situations where they might face danger. But really, they didn't go far enough. So it wasn't seen as a negligence issue. It was just seen to be not discharging their duties and obligations.
From memory, they argued that she had done a lot of this outside university time and of her own volition. What did the judge make of that argument?
Well, ultimately, the university stepped back some of those arguments. It initially did raise quite a lot of concerns with her around, as you say, the outside of sort of work publicity that she was doing, but they did step that back and recognised that a lot of the media interest, stories and work she was doing was linked to her role at the University of Auckland and was broadly part of her role.
Okay. She was awarded $20,000. What do you make of that amount?
So that is damages for the hurt and humiliation injury to feelings. So it's classic sort of compensatory damages. That's reflective partially on her individual circumstances. So she didn't provide any evidence of medical harm herself, and that is a key area where the courts will be guided on. The court was quick to say it's not there to punish her and highlighted her resilience through the process, but ultimately that's sort of the basis for how compensation is awarded. Penalties were sought against the University of Auckland for their breaches, but no awards were made in respect of that.
So taking that into account, it seems like quite a low amount.
Yes, it could be seen to be a low amount considering many of the other cases that we see in the employment law space. Awards are probably increasing generally.
Let's talk about how this might relate to, the workplace more broadly. If an employee is being harassed or stalked or something like that, and I think that's sort of the closest correlation to what Siouxsie Wiles went through, what are the employer's obligations in that circumstance?
So really the key starting point is to be proactive rather than reactive, and that involves undertaking risk management. So being clear of what the risks could be, and part of that relies, I guess, on your employees coming to you with information about concerns around that harassment, but identifying areas where the individual could be at risk, heading to work or away from work or in the digital space, particularly if they do have a public role, and trying to put in place steps to avoid harm before someone harasses the individual. Part of that is going to be, or it's an individualised, I guess, analysis where expert advice, I think, is needed. That's not necessarily legal advice. That is, I think, health and safety advice or consulting security advice. But ultimately, I think what's also important is to give the employee tools and resources to help themselves as well, to keep themselves safe.
I mean, does this come up quite often in terms of employees charging that they're not being kept safe psychologically or whatever? It's not really physical, is it, so much? It's the stress of the...
That's right.
abuse.
And it may not be harassment or stalking, but commonly we see a lot of psychological concerns come about with mental health issues. So the concept of keeping your workers safe can occur in any workplace setting where there might be stress, so restructuring, performance management, where there's investigations in the workplace. These are all sort of situations where mental health may be impacted and something that employers should be thinking about.
I mean, employers that read MBR and feed back to us are very concerned about the mental health thing, because obviously I think for a lot of people it's, you know, they feel like there's no way they could possibly contain every risk to someone's mental health. Is it fair to expect employers to do as much as they have to do?
The Health and Safety at Work Act does actually put parameters around what is reasonably practicable. So the difficulty is that there's no black and white line, and it's not the same in every situation. But the law does recognise that every employer is different, and what one employer should do is going to be different to the next. So their risk management, it should be achievable for an employer. I think it often feels like it's not, but the law does try and provide a framework that is reasonably accessible.
Just finally, do you think an employer needs to keep abreast of what their employees are doing on social media and things like that? Because that's, as you say, a platform for abuse quite frequently.
Yes, I think it is something that employers need to be on top of. And again, I think it's being proactive rather than reactive. So that might mean having policies in place around what sort of social media use there should be if purporting to sort of represent the company or doing media in your role, rather than waiting for a post to go too far or waiting for harm to arise as a result of that engagement. And involving, again, sort of experts around safety and online safety, I think is helpful. NetSafe do assist employers in that space. I think something that WorkSafe is also looking to increase its presence to provide more information to employers.
For more content just like this and all the latest business and political news, head over to mbr.co.nz.